Let's have a seat in the witness.
Not to be questioned, because the problem is him, not me. The problem is my attorney. So you're putting your forcing attorney on me that is not my choice.
I want you to raise your right hand and be placed under oath.
I affirm.
Do you solemnly swear and affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Have a seat. You affirm, that's good enough. Now, Mr. Saul is the 8th attorney that you have had in representing you on this post-conviction relief petition. I am not inclined to release Mr. Saul and find some other lawyer to appoint to represent you. He is.
Then I want to represent myself, Your Honor. 303, I'm giving you a notice of it. I want to represent myself. He's not done anything. Tom said he didn't ask you permission to get my witnesses. Today, I asked you in Dixon County, I mentioned this case. I told you about the witness. I told you I wanted to go after the jurors. I'm not, Your Honor. I'm not trying to be ugly. But I asked you on the record about Thomas versus State. I brought it up and you said, no, it's okay. You can't investigate the witnesses or get any funding to investigate the witnesses. I told you I needed the jurors' witnesses as my witnesses summons. I told you that about that. I mentioned it on the record, Your Honor, and that day it should have been went over. If the state wanted to contest it, they should have done it that day on these witnesses. I told you I had witnesses that I had to summons, and you said that I could put my own in, and the clerk would help me on the record, Your Honor. I'm not trying to be ugly, but they didn't contest it that day in Dixon County. State, and this is Thomas, right? I know the rules. And under Rule 8, it didn't say I had to ask permission to summons. It says I had to have permission to investigate them under Rule 8. And Thomas' case right here, I have right here, Your Honor. It doesn't say that I have to have permission because State versus Smith, he brought his back, his jurors. Faulkner case brought his back. Hill brought his jurors back. The Vanderbilt case brought his jurors back. And Rollins brought his case back under the same issues that I'm going under, Your Honor.
All right, put that piece of paper down. Now, we're going to address, first of all, your request to discharge Mr. Saul as your attorney. You understand that you need an attorney to help you with these issues that you've raised, and that an attorney is required to adhere to the rules and to the law, and can only raise those issues that this court or that the law allows you to raise on a post-conviction relief. And under the circumstances, because of the fact that you have subpoenaed, for example, your first subpoena on your list is the District Attorney General for the 23rd Judicial District, Ray Crouch. You have requested a subpoena for him. Typically, that is not something that would be allowed by the court to subpoena the district attorney unless there's some showing of a need or reason why. My intent is to allow Mr. Saul at this stage to simply allow you to state in a question and answer format why you believe each one of these witnesses is relevant to your case, and then I will consider that, and then I will make a ruling as to whether or not that subpoena should or should not be brought forward. Then my ruling will be an issue that you will have to, again, appeal. If you disagree with my ruling, you'll have the right to appeal it.
Yes, sir.
But I'm trying to simplify this procedure so that everybody's on the same page. So I am not going to grant your request to discharge Mr. Saul at this stage.
Right. Now, we want an interlocutory appeal on that, Your Honor.
Pardon?
Interlocutory appeal on that. Under Cook versus State also, under recusal, I want you to recuse yourself if you're not going to let my enforcement attorney on me. It's not doing his job. You have all my motions. You haven't went over none of my motions that I put in against Mr. Saul. None of them. He got somebody convicted of their own car, some of their own car.
Are you requesting that I recuse myself from your case?
I am. If you're going to force the attorney on me, that shows that something's not right here. That something's going on. I admire you. I try to respect you, but I just do not understand why you have not went over my motions at any of them. You haven't. You're just saying you're not giving me no benefit of the doubt whatsoever. You're not having went over none of my motions. I put 4 motions in to get him off because he's not doing his job. I can prove it if you allow me to. I can prove it.
All right. Stop.
Then we're here now.
Stop talking.
Yes, sir.
Under Rule 10 of the rules of the Supreme Court rules, when a motion is made for the judge to recuse himself, then the judge cannot proceed until such time as he has entered a written order to address that motion. So I will step off the bench and I will issue an order, and then we'll resume this. Have a seat.
I said only if you're allowing me to keep this attorney, Your Honor. And I apologize to you for being abrupt to you.
Reader, I have drafted an order that will be entered on the record that denies your motion to recuse this court. So we may now proceed with the question and answer form. I want you to understand one thing. What I'm doing today is to try to address your request regarding these subpoenas. And the simplest and most expedient way of doing that is to have Mr. Saul, who I understand you have issues with, but today at least, we're going to let Mr. Saul ask you the questions about why you want this particular witness and what they may prove or what they may establish in relation to your post-conviction relief. Then the state will be able to ask you questions. I will then have to issue an order regarding which of these subpoenas, if all of them or some of them can be issued, and they will be issued before the next hearing. All right. So if everybody's on the same plan, the sooner we can get through this, the quicker we can get a resolution. Yes, sir.
Well, I have intent to use. We can go over that today. I got also intent to use evidence in the post. We could address that if you want to. I got
What evidence?
Also,
pardon?
Also, I have the jurors I want, if they do come, or the witnesses I want them to be sequential, because the last time allegedly the DA talked to him before he came in to the new hearing, allegedly. But so I do want them to be sequential. You know what I'm saying? Now I got law to back that up, Your Honor.
All right. Well, number one, none of those witnesses are going to testify today because I'm going to have to resolve the issue about whether or not they should or should not be called. So keep in mind that today is all about you satisfying me that there is a legal and relative basis for those witnesses to be brought in to testify. So, Mr. Saul, I'm going to allow you have a copy of the handwritten list that he provided?
Yes, Judge.
All right.
Yes,
and if you will, please address each one of those. General, do you wish to let him go through the entire list and then cross-examine him, or do you want to do it as per witness? All right. So what we're going to do, so we're all on the same page, Mr. Saul is going to ask you why you believe a certain witness should be brought in under a subpoena. And then once you have testified about those reasons, the state will be allowed to then come to the stand and question you about, cross-examine you about the reasons why you've given. And we'll go through all 15 of your witnesses.
I think there's a few more I added, Your Honor. I'm sorry, I don't mean to interrupt you. There was a few more that I added.
2 more that you added.
Yes, sir.
And who are those?
Yes, sir. It was, I believe, 2 or 3. Mr. Fouch, he was one of the jurors, and then Miss Thomas.
I don't have
and
them in mind.
Miss Gazea, it's G-A. I mean, I have the list in my stuff, but and then it had Z and then I. She worked for Vanderbilt College.
All right, if you, well, I have 15 witnesses that were on the list you supplied on October the 28th. So if you have 2 additional ones, you need to go step down and retrieve those. All right, let's go ahead and start with the first on the list and move over. We'll work down to it and we'll get to the one he's added. So.
Yes, sir, Judge. Mr. Reader, if you could just state your name for the court, please, for the record.
Pull that microphone down so that you're speaking more directly into it.
Okay. Mr. Reader, will you state your name for the record, please?
Jimmy Lee Reader.
All right, Mr. Reader. Number 1 on the list that we've spoken of regarding potential witnesses for your PCR hearing. The first one I'd like to talk to you about is Mr. Ray Crouch. Can you tell the court why you feel it's necessary for Mr. Crouch to testify at your PCR hearing, please?
Yes, sir. Well, motion for the new trial. He made allegedly false statements due with a motion in limine when he said he wouldn't let any character evidence come in. and agreed to it on the record to the judge, and they all agreed to it. And my recordings were all character assault and talking about other people that wasn't relevant under State versus Moore. And it was supposed to be retracted everywhere that they agreed to it. It was supposed to be, even the appellate court, it's in my brief, it says that they agreed to it. It was supposed to be retracted. Anywhere I asked for an attorney, the jury wasn't supposed to hear that. For what reason, I do not know, because it seemed like to me it'd be more of an issue under Miranda warnings and issues of talking about attorney. And, you know, under Arizona case, that it wasn't really supposed to come in anyway, but that they asked for it to be retracted. Also, he said on the statement, well, we're not going to let it come in unless anything about his prior records or anything like that, unless he gets on the stand. Well, State versus, I believe it's Smith. You can't rely, you can't put somebody in fear to keep them from getting on the stand. Not only that, they alleged, he assumed, which I think he thought it, that there was only a letter, and that was the motion that Mr. Baum and him agreed on. But it was really talking about, Mr. Baum didn't put the motion in correctly. He was supposed to put in, you know, the 404B ruling, and, you know, 404(1), 2, 3, and, you know, and relevance and all that kind of stuff. Judge Sexton, I believe it was. It was supposed to, but they were alleging that the state was alleging all they had was a letter. They didn't even say anything about using my recordings or anything at that time. And so I'll give Ray the benefit of the doubt. He didn't, maybe he just didn't know that they were talking about the letter and not about the recordings. So we have to bring it back to clarify that. And then Mr. Wilson was there also during the new trial, and they could have just put him on the stand, which they asked, do you want to put Mr. Wilson on the stand to answer several questions about certain issues that they agreed on, but Mr. Baum felt it never did that. So I need to also Mr. Wilson for that reason too.
All right. So I don't want to continue into we'll talk about Mr. Wilson in a moment. So essentially what you're saying to the court is Mr. Crouch would be necessary because he would need to be able to articulate whatever the agreement was regarding a motion in limine regarding your Fifth Amendment rights and when you invoked your right to counsel.
And character assault, the Tennessee rules, they ruled on not to let any character evidence before my trial. It's in the I have the motion limine with me right now. Okay. And it says that he agreed on that for it not to come in.
All right.
Also, Mr. Krause needs to come back also because it's a jury issue that he played football with a juror, and he also went to school with a juror. That is allegedly Mr. Fisher, Robert Fisher, Robert Allen Fisher. So he went to in school with him on that issue, and he was asked by the court several times, do you know any parties involved in this case? And he never came forward about, actually kind of knew me a little bit through just we do contractor work and stuff and everything. But he also, we're dipping into Nariel, we're dipping into Robert Fisher on another witness, but they're tied together on that issue.
Okay. Ms. Say you have some questions for you about Mr. Crouch. Thank you.
Morning, Mr. Reader. Hello. So just a couple questions about General Crouch and your trial. Can you hear me okay?
Yes, ma'am.
Okay.
I do have trouble hearing now.
So you said that you needed General Crouch to come back because he had knowledge of a juror. Is that what you're trying to assert?
No, he had knowledge of, well, I don't think he had the knowledge. That's a problem. So we have to clarify that. I think that he thought it was he says on the record, he thought it was a letter that had to do with the motion in limine and not it had to do with my recordings, which they should have had, Mr. Baum should have had that clarified up before my hearing. My trial. He should have had it clarified.
They did in fact discuss that on the record at trial. There was an objection about that, wasn't there?
They had a bench conference about the issue, and he didn't mention anything about the letter, but he did mention it in the new trial. But they said, well, we can have Mr. Wilson's here. He can clarify it up if he wants to get on the stand, if he's talking about the letter, or if he was talking about other things. But he's also said that that he would let no character evidence, I got the motion limit with me, that no character evidence come in. The whole recording is nothing but a character assault. I'm talking about things to do with my ex-wife, the things that we went through, custody issues, my niece, some things happened with her, allegedly with my son, and some things, and the jury's getting to hear all these irrelevant things because, why? Because they didn't hold up to their agreement, the state did. And Mr. Baum argued that at new trial, but they didn't put Mr. Wilson on the stand to clarify all of it with Mr. Wilson.
Okay, but all of this, we actually have a record of what happened at the motion for the motions in limine, right?
Mhm.
And we have your trial transcripts, and we also have your motion for new trial where this was discussed, right?
Yeah, and
Yeah.
it has exactly that Mr. Crouch is talking about Mr. Jones, like putting him on the stand, like he's talking about something to do with that. And then when we come back from new trial, he says he's not even talking about that during the motion. He's talking about one of the officers. I have to look at during the motion of the term, but it's in my petition where he says that that he thinks, oh, I'm thinking about this, but he clearly knew what he was talking about during the bench conference, because he said Mr. Jones in the letter, but he didn't say the officer, so he swapped it around when he came to the new trial, so that wasn't correct.
So what I'm hearing is that you have a legal objection to something, some evidence that might have come in at your trial, and
Yeah.
not necessarily about General Crouch, but what happened at your trial.
404B ruling, Mr. Baum,
Right.
Mr. Cross didn't have it clarified. Also, they put fear in me not to get on the stand because he said that if I got on the stand, that he was going to bring, ask me questions about my past and other things like that. But if I didn't get on the stand, that he wouldn't. And he put fear in me not to want to get on the stand in that issue. And in my brief, you'll see that there's cases backing it up that you can't do that to a petitioner.
So what I'm hearing is really your issue is with Mr. Baum and how Mr. Baum handled something, not necessarily what General Crouch said in the courtroom.
He didn't say in the courtroom. He said that at a bench trial, he said that he didn't clarify that he was talking about a letter. So Mr. Crouch thinks he's talking about a letter. Mr. Baum may be trying to trick the state. I don't know. By putting statements in, but either way, Mr. Baum failed to do his job. And I'm not saying it's all on Mr. Crouch's part, but it was confusion between him and Mr. Wilson, so it has to be clarified. That's why we need Mr. Crouch here to clarify with Mr. Wilson to find out exactly. So there was no letter. Let's put that to the test. I do not know why they mentioned the letter or how they got the letter involved. There was never a letter from Mr. Jones about me saying I did something as bad as murder or some kind of type. Never was. If you can prove it or show it to me, I'll be glad to read it, but there never was. I don't know where that came about. Mr. Baum knew exactly what the recording said. And they asked me, I think one time, and it's somehow or another, it's on the recordings multiple times, allegedly. But me talking about that statement I just said about supposedly, allegedly doing something as bad as a murder, but it's never nowhere on the letter. And they never called Mr. Jones to the stand. And he said he was not using any character evidence. They both were confused about the character evidence that was supposed to come in, but they did agree on not to, they agreed on to retract, where I asked for attorney multiple times. I mean, I'm low educated at the time. Of course, I've improved a little bit. I had my disability at the time and stuff because of that. And I have records to back that up, but of course, no one has looked into that. So,
Mr. Reader, I'm just going to ask you to put a pin in that so I can ask you a follow-up about a different question. You talked about a juror that you said played football with General Crouch, and that's an allegation. Is that one of your allegations, that there's a juror bias with that individual?
Mr. Crouch?
With that juror?
Mr. Crouch's wife went to school with my ex-wife. We had custody of my kids. I put a motion into, I asked my attorney to put a motion in to recuse herself from the case because him and his wife, plus she worked at the paper and stuff. And I put multiple things in the paper and stuff, but not for that issue so much as it is my ex wife at the time had custody of my kids. Supposedly he did say that he tried to talk to her on Facebook, but supposedly she wasn't answering. I don't know if that's a fact or not, but
So I was specifically asking about the juror that you said. You mentioned a juror that played football with General Crouch in high school, and you thought that was a...
Yes. Robert Allen Fisher went to school allegedly with him.
Now, Mr. Reader, you would agree if you went to school with probably a lot of people, right?
When you ask a question, you're supposed to answer it. You're supposed to respond.
Do you know everybody? Do you know everybody in your high school? Did you know everybody that you went to high school and all of their names?
They played football together. That's pretty close.
Do you have
especially when allegedly your sister made allegedly videos with the football team, and it's the same kind of issue. But anyway, we'll get off on that. But yeah, there's other reasons they can be brought up.
All right, so are you alleging that Mr. Robert Fisher made false statements? Is that what you're alleging?
No, I'm alleging that Mr. Robert Fisher, Allen Fisher, did not come forward and respond. And it's a Supreme Court ruling that you have to respond to questions in a order. Okay. It's in my petition.
Your Honor, I'll pass the witness.
Well, so that I'm understanding and clear on this, if I understand correctly, your need for General Crouch to appear as a witness is relating to what grounds on your post-conviction relief? There's specific grounds that you have to allege. So what grounds are you alleging that his testimony would relate to?
Well, I think it's in the first part, and it's also in the last part where it says the 404B ruling where they didn't retract.
The grounds that you've alleged are ineffective assistance of counsel, juror bias, misconduct by the district attorney in statements made to the jurors. I'm asking you as to General Crouch's testimony, which of those grounds will his testimony relate to?
It's under prosecutorial misconduct and I have to look at my petition, look at the grounds.
That's all right. I'm just asking if you can tell me how you think his testimony relates to the grounds that you've raised.
Because he agreed to something on the record on not putting any character evidence on, and he did.
Right.
And also he informed me that I could, if I got on the stand, that he was going to use the character evidence against me, which he still used character evidence. My whole recording is a character assault. It's talking about religion. It's talking about other things. It was irrelevant. 441, 402, 403, 404B. They never had a defined ruling on it, and in those settings, and they should have. So we could actually blame it on the court, actually, also, to a sense.
Thank you, Mr. Scott, Mr. Saul. You may ask about the next witness.
Mr. Reader, it's my understanding that Mr. Robert Wilson was the original prosecutor on your case, correct?
Yes, sir.
All right. What testimonial evidence do you think that Mr. Wilson can offer as it relates to your petition for post-conviction relief?
Well, I think it was just rooted in, counsel. It was rooted in what we just were talking about. The main issue was well, then we have to go into more juror issues. Larry D. Fisher was accused of indicted for 27 indictments for sexual, for child rape and incest. And Mr. Wilson was the DA on his case, along with Jake Lockwood as his attorney, which was my attorney also. And for new trial, we brought back Miss Fisher, Rebecca Dawn Fisher, and asked her specific questions about Mr. Fisher. And she got mad a little bit because Mr. Baum said it was her uncle, and he didn't really have her clarified when, where, and who, the appellate court said. the exact offense, the time of the offense, you know what I'm saying, what type of offense, and when and where it happened or whatever. It's in my petition, and it explains all this that I'm saying. They said that, well, we could put him on the stand, and well, they could put him on the stand for that issue as well, and he would have clarified that, yes, Mr. Larry D. Fisher does have multiple indictments and was charged with 2, one of rape for 16 years and one incest for 4 years. And if they would have put him on the stand, they could have fled. I mean, we can do it other ways if under the intent, if they allow me to use the indictment, or let me use his judgment papers, which are public record.
Right. Well, let me ask you.
I don't have to have Mr. Wilson for that issue.
Okay, well, let me ask you this. What testimony do you think Mr. Wilson could offer that's specifically related to the issues you're raising about your PCR petition? Like, what is it that he could say that's related to the PCR?
The issue that compounded the ripple effect, the cumulative effect, where he said that all he had was a letter that he was going to use against me to Mr. Sexton in the first motion, the limiting and suppression motion, and which was not true. As far as I know, there never was a letter. It never was produced to the court or me from Mr. Jones.
So it's really related to the motion in limine and the use of.
Well, it was a ripple effect that caused Mr. Crouch to do what he did by possibly mistake, but Mr. Baum knew that it was not a letter. I mean, there's no way that he didn't know. I mean, I'll tell you the truth. I mean, maybe he done it for a reason. Who knows? I don't know. That's between him and God. You know what I'm saying?
Okay. All right. Thank you.
General Sagi.
So, Mr. Reader, again, your real issue with Mr. Wilson is really what Mr. Wilson and your attorney, Mr. Baum, agreed to, or anything that Mr. Baum was engaged with Mr. Wilson. That's correct? The first
suppression and limiting to Mr. Sexton, yes. And also the jury issue that he could have put him on, Mr. Baum could have put him on the stand that day and clarified it. And I would have had some kind of alter judgment or something that particular day, 9.5 years ago on the new trial. If he would have just put him on the stand, the appellate court said I didn't ask when, where, and who. Mr. Wilson could have clarified it up if he just put him on the stand.
So really, this relates to the ineffective assistance of Mr. Baum and why Mr. Baum did or didn't do something. Is that correct?
Right. Yeah.
I'll pass, Judge.
All right, thank you. Mr. Saul.
Mr. Reader, the third person you've listed that you want to have come in for your PCR as a witness would be Miss Kim Stringfield Davis from the Child Advocacy Center. What testimony do you think she can offer specifically related to the issues of your PCR?
She's the one from Nashville, I believe, the nurse practitioner, I believe in Nashville.
Ms. Springfield was the director of the Child Advocacy Center at the time. She is no longer with the Child Advocacy. She is no longer the director, but she was, if I understand correctly, the director of the Child Advocacy Center at the time of your trial. So that would be who she is. Now, Mr. Saul is asking you, and I will ask it as well. Why do you want her brought in to testify? What is it she's going to say that you think relates to an issue that's before the court?
She used a book, 2 books. It didn't bring the books and didn't have the books with her. And the rules that I put into play, I believe the state, it's a Fisher case also. You can't, if you don't have the book in front of you, or the state doesn't have a copy of it, or your attorney doesn't have a copy of it, then therefore you can't use scientific evidence in your favor that it's not presented to your attorney or to the state. And she didn't do that. Also, she made statements about time delays and stuff, and the Supreme Court rulings, it's clear on it. You cannot make any comments about time delay. I have the case with that. And also she's made statements about she had 45,000 children that had never, only 1% showed signs of penetration, and the ones that she has interviewed. Well, my attorney didn't ask her, you know what I'm saying, on the Chapman case and stuff, he didn't cross-examine her the right way. He didn't ask her, okay, well, those 45,000 children, how many of them were the people convicted, or how many of them people do you know were actually these things happened to them just because they alleged them? Because, you know what I'm saying, he should have, at least the jury should have heard that and her reactions to that statement. So because she's making statements that implying that, you know what I'm saying, to the jury, that all those cases could have been, all those things could have happened to them, which a lot of times is not the case, Your Honor.
Right. Mr. Reader,
or some other situations happen.
I want to make sure I understand. So your thought is, or with respect to Ms. Davis, is that she could be asked some questions that should have been asked by Mr. Baum, right, and then the court can consider whether or not that may have had an effect on the jury's deliberations.
Yes, sir.
Okay. Thank you.
You know what I'm saying?
So, Mr. Reader, we're discussing Ms. Stringfield, who, as Judge said, was the director of the Child Advocacy Center at the time. If you recall, at your trial, she's the one who had the videos. She's not the one who examined the victim. So why do you need Ms. Stringfield to come testify? She was the witness who placed the two victims' videos.
Okay, I've got her mixed up with Miss Gallatin, probably. Miss Gallatin is the one that I guess was at General Hospital. So we'll have to probably re-ask the questions, I guess, because yeah, so, I had them mixed. I guess I had, that's what I was thinking. I had them mixed up.
So why do you need Ms. Stringfield from the Child Advocacy Center?
I need her because she had some that were marked 1, 2, 3, and 4, I believe it was, but then they only presented and implied that there might have been another recording. I don't know if they ever had, if someone else in the room was recording, or if they even had security cameras that were recording.
Yeah, I think at your trial they went over that there were 2 videos for your case, and those 2 videos were authenticated and placed there, and the testimony was that they just didn't know why they were labeled.
Right.
2 and 3. Like those are the 2 videos.
Right. I mean, that's a good point. We might not need her, but I just figured that she would be there, but for in case something popped up, you know what I mean, that we need to go over with Miss what is it, the one that was, I guess the one. But
that was already questioned. They already questioned that in court. Like they already took care of that.
Well, she said as far as she knows, so that means she didn't take them. So she didn't definitely answer the questions, what I'm saying.
But there was testimony that those were the 2 videos that went with your case.
That's what I'm saying. But he asked her, was there any more? And she didn't definitely say she said as far as she knows. That's not a defined question. You know what I mean? It's not, I mean, it could be, may not be.
All right. Mr. Saul, we're moving to number 4.
Yes, sir. Mr. Reader, with respect to the 4th witness you've listed, it's Miss Allison Goldberth from the Child Advocacy Center. What specifically do you think that she would be able to testify to as it's related to your PCR?
That's the one from from the same place as Miss Davison, I believe.
Right. She's
so
the same
well,
office.
under the rules, I need my petition, Your Honor. It has all the set rules under when you let a video come in and she wasn't here. They didn't ask her about her training. That the rules say you have to do that. They didn't ask her, how long she'd been there.
Okay.
They didn't ask all the guidelines. That's why we have to bring her back to
Okay,
ask her about all the guidelines.
Okay, let me characterize it this way. I think it's similar to what you stated before related to Ms. Stringfield Davis, and that is this. Your thought is, you tell me if I have this right. Your thought is that Mr. Baum didn't properly cross-examine or examine Ms. Goldbreath. And as a result, certain questions need to be asked of her that were not asked at trial so that this court can determine if her answers to those questions would have had an effect potentially on the jury's deliberations. Is that sort of the nutshell
Well,
version?
no, the omission of the video also, well, yes, but the omission of the video, there's the guidelines that the Tennessee codes have set forward to let those kind of videos come in. And if you have to go by those rules, and no one did that. No one even mentioned anything about the rules at that time. And so I have to bring her back and prove that Mr. Baum did not do that, or the court or the state did not go follow the guidelines of how long she'd worked there, and did the person really need to, I'm saying, these
Right,
videos. It's just like all kinds of
I understand,
guidelines.
but
If I could have my petition, it has all the rules in it.
Here's my question. If what you're alleging is there were procedural flaws in how she was questioned, then is her testimony really necessary, or can the court just look at that and say, well,
Absolutely.
Mr. Baum fell below the standard? Okay, but you're thinking that she needs to be able to be here to testify as to what she would have said if she was asked the appropriate questions.
Well, I mean, the point is, I have to prove that Mr. Baum did not follow the guidelines of the codes of letting video things in that. Okay. And I have to prove that she was, how long she'd been, doing it, interviews, and all the guidelines that come along with that. It's 24 something other code. It's in my petition.
All right, I understand. Thank you, sir.
She'll say.
So, Mr. Reader, are you asserting that Ms. Allison Galbraith testified at your trial?
Miss Alvin Galbraith?
Allison Galbraith?
We're getting these mixed up. If I have my petition, Your Honor, because I cannot remember exactly which ones.
You may step down and retrieve your copy of whatever you need to refer to.
Okay. Miss Gallatin testified. Following, she is the one from the one from General Hospital that did the first interview. It never did a second interview, even after the other people did the child advocate. I mean I guess this is Kids R Us, I believe. I mean, not Kids R Us, our kids. And Ms. Gallatin testified as an expert. She was qualified as an expert in diagnosis. Ms. Gallatin is the one who made all the statements. So we're going to have to back up. I apologize if I had this in the beginning. Ms. Gallatin is the one that testified the following about all of the issues that we talked about with the book and about 4,500 children. Your Honor, I apologize. I should have had this in front of me. That's Ms. Gallatin, Your Honor. She qualified as the expert diagnosis treatment of children, sexual abuse treatments.
All right, so re-ask your question and again, let's see if his answer now that he's refreshed his memory.
Your Honor, I'm just trying to clarify because Mr. Saul asked about Ms. Galbraith, not Ms. Gallion. So
I have Miss Galbraith. Allison Galbraith is number 4 on his jury list. Miss Holly Gallion is the second, or is number 5 on his list. So we're talking right now about Miss Galbraith.
I believe she was the one that took the initial interview. with,
So to
Ms.
clarify,
Andrews.
she did not testify. Allison Galbraith did not testify at your trial.
no, man, that's why we need to bring her back, because she needs to clarify, because she didn't do the initial interview on, under 412 of allegedly, Mr. Baum had Mr. Barnhill, was allegedly had done stuff to EMG.
So I'm just going to clarify this. So you're asking for Ms. Galbraith, who did the original child advocacy interviews of the victim, to come into your post-conviction to show what, ineffective assistance of counsel?
She has to be there to give the statements of her medical records, because she's the one that took the intake, and she's the one that actually took the interview, and she's the one that made the statements about everything. And they asked her if she had any prior allegations against anyone else, and she made those statements in there, or she has knowledge of the alleged things that happened.
So is your issue that your attorney did not call her as a witness?
Right.
Okay, so
I'm so sorry.
okay.
Yeah, I'm like I said,
I'm just trying to keep these
I'm
clear.
not the smartest apple in the wrench.
So your issue is really why Mr. Baum did or didn't choose to use this witness. Is that correct?
Right. He didn't call her or ask her, and the issues were, they were saying in court, because he didn't call her, which is in fact that's true. So, and he needed to go over, and they have to be introduced, her medical records, what I'm saying, or her statements during that interview, where they asked her if she had any priors and stuff, and it'd be in her statements and stuff. They didn't let any of her medical paperwork come in, or any of her statements. Under Rule 412, we have to address that, and that comes into play.
So just for clarification, at your trial, Ms. Kim Stringfield, the director of the CAC, was the witness that introduced the videos of the victim in her 2 interviews.
Who did now?
Kim Stringfield,
Right, exactly,
yeah.
right.
The interviews were actually conducted by Ms. Allison Galbraith. You want to bring Ms. Galbraith into your post-conviction?
No, again, we're getting them mixed up again, and I apologize. I'm getting them mixed up with the one that did the initial intake in General Hospital. That's Miss Allison Martin, I believe it is.
But right now we're talking about Allison Galbraith, the
right,
lady that did the interviews.
I apologize.
Okay.
Yes, ma'am. I'm
So,
sorry.
and your issue really is not with the interview, it's the fact that Mr. Baum didn't call her as a witness. Is that right? So it's really Mr. Baum that you have the issue with.
Right.
Okay.
Mr. Baum didn't call her as a
All right.
witness.
Thank you, Judge.
Not only the reason of that is because, she was supposed to, I'm saying that, under the same guidelines, under letting the interviews come in, she has to be here before they.
But that's an issue for that's an issue with Mr. Baum.
The issue is that, yes, but she wasn't here to say how long she's been working and all the guidelines that has to go through with letting child, videos come in, and they didn't go by any of the guidelines, and she has to be here before and ask them all the questions. Miss Davidson wasn't the one who did the interview, so they have to bring her.
And that was explained at your trial, and but right now your concern is that Mr. Baum
Correct.
did not. Okay, thank
Correct.
you.
I'm so sorry. I should have got all this name straight before.
All right, number 5 is Holly Gallion.
Yes, Judge. Mr. Reeder, you've mentioned her in some of your previous testimony, but I want to make sure we're clear. Number 5 on your list is Mr. Holly Gallion from Our Kids. What's the testimony that you believe she can offer that's specifically related to your PCR petition?
Miss Holly Galvin, like I said, I apologize for getting them. I got them confused and stuff. I didn't have the paperwork in front of me. I apologize to the court and to the state. But Miss Gallatin was the one who came, and she was the nurse practitioner, and she's the one to make the statements about the 4,500 children that I was talking about earlier. And she's the one who had the medical records And that's the reason I really needed to bring her, because to bring the medical records into play, because of, they have allegedly and have all the statements of prior accusations against someone else, against Mr. Barnhill.
Okay. So your thought is that she wasn't properly examined by Mr. Baum.
Exactly.
Okay.
Exactly. And I think there could have been several questions you could have been asked on all the, and about the book that she brought in. I needed to, she made these allegedments about all these things in the book that I'm saying it's normal to be normal supposedly about this book, but Mr. Baum never got the book. You know what I'm saying? And it says in my petition, the law that I got with it, you can't borrow other people's scientific evidence like that. And so, especially without having, and the case was overturned because they didn't present the books to the state or present the books to, his counsel.
I understand. All right. Thank you, Mr. Reader.
Bill Seggy.
So, Mr. Reader, again, this witness, your issue is really that Mr. Baum failed to do something, right? But Ms. Galleon's testimony is all, she was an expert witness. Do you remember that? She was qualified as an expert at your trial. And so we have all of her testimony, but your issue again is that Mr. Baum didn't effectively cross-examine her or give you information. Is that right? You wanted a treatise that she referred to?
Well, also, and Mr. Cross made statements in his closing arguments that she didn't, it's in my petition that she didn't actually make. She made allegedly comments in her petition. Mr. Crouch in his closing arguments that he alleges that she said that she didn't. And I need to bring those issues in. I believe it will come out into the petition. I mean, even if you do a post-conviction, things can still evolve and come out. And there's several reasons why you need the witnesses, because it can evolve and you can preserve that for the appellate court ruling under 403 and other things.
But under your petition,
103, I'm sorry.
Ms. Galleon, you want her because Mr. Baum failed to do something. Ultimately, Mr. Baum you're trying to allege that he was ineffective because he didn't ask for a book, a treatise, or object in a closing argument.
The two books, one was Normal to be Normal, and then another one was in 2000, Nurse Practitioner book. And I have the law in my petition to back it up, that it says that you're not supposed to.
So, but again, it's an issue with Mr. Baum not doing something.
Yes. Well, okay. Mr. Crouch can testify that he, and she can too, that she never provided one to the state nor to Mr. Baum. And that's what the case that I got in here is about.
But just to keep focused, the petition that you have is ineffective assistance of counsel with Mr. Baum. So the proof that you're looking for here is
right.
Okay.
The issue is about.
Thank you.
I'm sorry. Yes.
All right. Number 6 would be
Mr.
John Martin.
Yeah. Mr. Reader, you mentioned your list of witnesses, number 6, Jaha, that's how I'm pronouncing it, Jaha Martin with our kids.
Mm-hmm.
What testimony do you think that witness can offer as related to your PCR petition?
Well, she wasn't here to be questioned. She's the one who done an initial interview. Several people, Miss Penny Hackett was there, and she was supposed to be the one that took the initial statements. They took the initial police report from her. It's in the presentation report, and no one even presented that at my trial. Because it says that she alleged. That she says in statements in it that it says that I allegedly attempted to make the person do something. So it didn't have the initial statement. It didn't say that I did do it. The first initial statement in the police report doesn't say that. And that's one reason that needs to be clarified, because what did she say at that also at that interview, and what were the statements of her?
So it's your position that this witness, J. Martin, would be able to offer testimony that should have been offered at trial, but wasn't by Mr. Baum. Mr. Baum didn't call the witness.
Right.
Okay. Thank you.
Thank you, sir.
All right. State has no questions about that witness, so we'll move to number 7, Rebecca Underwood.
Yes. Mr. Reader, same question as it pertains to Miss Rebecca Underwood with the Department of Children's Services. What testimony do you think Miss Underwood can provide as related to your PCR petition?
I need to know if she did interviews with Mr. Barnhill or Miss Barnhill or with NG. If she made any comments about Mr. Baum, which we do have records on it that our aunt did, but supposedly she didn't. But I don't have her initial interview. And did they do it on recording? Because I know, because situations that have happened in my family, but I know Miss Galbraith does the first thing she does an interview. So did she make a recording interview?
All right. So your position is that Miss Underwood could offer testimony about interviews of the Barnhills and the victim potentially
On allegedly other incidents with Mr. Barnhill.
Okay, I got you. I got you.
And
All right.
NG.
And that Mr. Baum failed to do that.
Under Rule 412, yes.
Thank you, Mr.
Thank you, sir.
Gentlemen, you have any questions on this witness?
You recall that this was litigated already and told that it was not allowed in, anything that dealt with the Barnhills and anything with that. Do you remember that being litigated?
I remember it being that Mr. Baum failed to put in a motion prior to 10 days, but then they allowed the state to do the same thing without the 10 days. So what's good for the goose is good for the gander. And on certain issues, they didn't, especially on my interview, they didn't put intent to use it or anything, or tell the judge that they were going to that until that day, and they signed a petition to keep Mr. Baum's statements out because they said Mr. Baum did not file under Rule 412. He didn't file within 10 days of the court.
Right.
But then the same thing, the state didn't do the exact same thing on other issues, but they allowed them to do it.
Well, I think that's probably because the type of motion that it was, specifically what a 412 motion deals with. But you do remember that this was something that was in fact discussed. And your issue is really that Mr. Baum failed to do something, correct?
Right. Well, Mr. Baum felt it, but Mr. Crouch made statements at the new trial when they discussed it. And then it could have been borne out by Mr. Wilson also. If they put him on the stand, again, they didn't put him on the stand, Mr. Wilson. And Mr. Crouch made statements that were actually not even in no paperwork that were presented to the court as an exhibit.
So, but why do you need this specific?
Under Rule 412?
So what you're asking is that your lawyer failed to file a Rule 412 motion. Is that it?
Yes, ma'am. He didn't do it for 10 days before trial. They let it come in. Yes, ma'am.
Okay, so that's an issue with your lawyer who had the information. All right.
Yes, ma'am.
We'll pass, Judge.
Yes, ma'am. I'm sorry. I'm trying to do the best I can. I'm not the brightest pumpkin on the farm. I've been through a lot, ma'am. I'm sorry.
All right, now we're at number 8, Rebecca Dawn Fisher.
Yes, Judge. Number 8, Mr. Reader, Ms. Rebecca Fisher. What testimony do you think she can offer or needs to offer as related to your PCR petition?
Miss Rebecca Fisher. Mr. Baum brought her back for new trial to ask her questions about her brother-in-law, which he called her uncle, which was not true. It upset her, and so she did say, he said the exact he said he's done this, allegedly sexual things against your niece and stuff like that. And she said, correct. And she said also, and then he asked her again, and something to that effect, and she said correct again. But then she said, after that, she said the statement that he's not my uncle, he's my brother-in-law. So the appellate court said that it proved biases. I mean, it presumed biasness, but I couldn't prove the biasness, but because he didn't ask the exact defense and circumstances around the offense and the time and place of the offenses. He didn't ask those 4 questions. The appellate court laid those rules out in my brief.
So
that he failed to do that.
So, Mr. Reader, as it pertains to Ms. Fisher,
Mhm.
Ms. Rebecca Fisher, is it your position that she could offer testimony that if she had been asked certain follow-up questions, that would have then disqualified her as a juror?
Yeah, under State versus Smith, it's unreasonable not to ask if you've been convicted of a crime, or you know anyone that's been convicted of a crime, or do you know anyone that's been convicted of a crime? And it goes into the federal level as well. Under State versus Smith, Faulkner versus State, Rollins versus State, and all those cases were overturned because of that particular issue. So anyway, getting back to the reasons why I knew God is because he didn't ask the exact offense, or he didn't ask what type of offense was, where it happened at, and the surroundings around it, and he failed to do that. And he failed to ask during the trial, have you ever been convicted of I'm sorry. Has anyone you know have been convicted of a crime, or been a victim of a crime, or anyone that you know has been convicted of a crime, or have you been convicted of a crime? Which I just said it backwards, but anyway, have you been convicted of a crime, or anyone that you know has been convicted of a crime? Is what the Supreme Court ruling says under State versus Smith, says you have to ask that. I believe it falls under through Johnson.
Okay.
So
your position is Mr. Baum didn't conduct enough voir dire with Ms. Fisher, basically.
Well, also, yes, and he didn't bore out, her testimony on that issue, and I have to get him for not asking the question as well. And you can't, under 606B ruling, that the state's going to try to say, well, did you take it to the jury room with you? No, you can't ask it under 606B ruling. It's a federal court law under Wash versus State. You cannot even ask that question. And they're going to try to, oh, it wasn't enough to affect it. And, you can't rebut that way because you can't even ask that question. Anything to do with on your mental process going into deliberation, you cannot do that. So there again, I'm just letting the court know that that's what they did last time when I brought back Ms. Fisher's. They told her, they said, oh, we credit her testimony because she said that she didn't take it to the delivery room with you. Well, under 606B ruling, which my attorney didn't appeal that the right way and put that in there, the 606B ruling, and say, well, they really weren't supposed to ask that question.
Okay. Thank you, Mr. Reader.
Under State versus Smith, 2011.
Senator Sagi?
Mr. Reader, so you referenced Ms. Fisher. We're talking about Rebecca Fisher.
Yes, ma'am.
And she was a juror at your trial. And you also recall that she was called as a witness at your motion for new trial. Do you remember that?
Yes, ma'am.
Okay. And at that motion for new trial, Mr. Baum actually called her as the witness. Do you remember that? Like
Yes,
your lawyer did that.
Yes, ma'am.
And he went to go ahead and ask her some questions about whether or not she knew you, and she said no, but her brother, that you might have worked with her brother, and that would be the only.
Did she really make that statement you just said?
So on page 15 of the motion for new trial transcript,
Because that's not what
Rebecca Fisher, she's asked by Mr. Baum her full name. She says, Rebecca Dawn Fisher. Ms. Fisher, were you a juror at the trial in this matter? She says, yes, correct. Do you recall the time when the attorneys were asking questions of the potential jurors? That would be your jury selection. Yes, sir. And I believe, I don't know if it was me or General Crouch, were asking you questions about whether you knew Jimmy Reeder or not. And you said you did. She says, right. And I believe you said that you knew him because your husband had employed him at one time. She says, no, my brother. He worked for my brother, but my husband worked for my brother as well. And he says, okay, was that the only way you knew Jimmy Reeder? She says, yes, at the time, yes. I didn't know he had grown up with my brother, but he had grown up with my brother. And your husband, Wolfe Fisher, yes, correct. And he used to deliver beer to H.G. Hills where Jimmy Reeder worked, correct? Yes. He says, I have no idea what route he drove. I have no idea. So your husband never talked to you about talking to Jimmy Reeder? No. And your husband also coached Abigail Reeder? Not that I recall. Your husband's a soccer coach? Yes, sir. Are you aware at the time Jimmy Reeder was also a coach? Yeah, a long time ago. Yes, sir. And there was a time when you were on the board of directors of the soccer league? Yes, sir. And you were still on the board of the directors when they ruled against Mr. Reeder on something and took out the 2-page ad in the Ashland City Times? No, sir. Like, do you recall this part of her testimony? Okay.
I mean, I didn't call the board here, but over that, but that's a false statement.
But
Allegedly.
and then it was already litigated about whether or not she knew a potential other witness in this case, Jody Jones, since that was discussed. And then when the last time was they talked about it, but this was all extensively litigated. And then of course at the they ask about Larry Fisher, your claims that he was convicted of a sex offense, and she corrected, he's my brother-in-law, he's not my uncle. Brother-in-law, yes, sir. And you didn't disclose that at the time of trial, correct? And she says, I didn't. I guess I didn't think anything about it. He's been put away a long time. So, and then Mr. Baum says nothing further. General Crouch gets up there. He objects to things under 606, but that was overruled. And General Crouch asks you some questions if she had ever known the facts of the case. She says no. And he asked, did you go in with your mind made up whether you were going to acquit or convict Mr. Reeder? And she says, absolutely not. And did you make up your mind after you heard the evidence in the case? She says, yes, sir. Did you deliberate anywhere other than in the jury room with the other jurors? No, sir. And then Mr. Baum asks more questions about extemporaneous materials. She didn't know what that word meant. Anything else that you didn't hear in the trial? Did they bring up life experiences? And he says, oh, no, sir. Mr. Baum asked, did you ever talk about your brother-in-law? She says, no, sir. Did any of the other jurors talk about personal experiences? No, sir, not that I recall. Did any of the other jurors mention that they might have known any of the witnesses that testified? No, sir. And that was their questioning. So basically, she's already been questioned about whether or not she was biased in the case or influenced. And she said no. You do recognize that she has.
You can't ask that question. 606 ruling says you cannot ask that question. The problem is, I'm saying she didn't respond. Mr. Baum said he wouldn't have the opportunity because Mr. Baum didn't ask the question. He didn't ask, have you ever been convicted? Under State versus Smith, it's unreasonable not to ask that question. Have you ever been convicted of this crime?
Ms. Fisher's never been convicted of a sex offense.
Have you ever been a victim of a crime, or do you know anyone the victim of a crime? State versus Smith, words for words, what it says. And she did not. And because Mr. Baum failed to ask that question, but the other jurors, the public court recognized that the other jurors came forward, but she didn't. Mm-hmm. And all the statements you just said practically are under the rule of 606B ruling. You can't even ask those questions, but they can't even take those into consideration.
But she never once said that she was biased or.
That's not the problem. She never had the opportunity to respond to the question. Judge. She never had time to respond to the question because it was never asked.
All right. Now we're moving to 9, Robert Fisher.
Can you fall back into that a little bit, please, sir?
With respect to, is it Robert or Roberta Fisher, the 9th one that you listed, Mr. Reeder? I may have miswrote it. Is it Robert
so we
Fisher?
Can't recalibrate on this real quick?
Alan Fisher.
Yeah, I'm sorry.
I'm talking about Ms. Rebecca Fisher.
Couldn't understand my own writing, Judge.
Because she had skipped over some things that in her statements that wasn't actually, she just overlooked some statements that she said. Right here.
Mr. Reader, my question is related to Mr. Robert Fisher. What testimony do you think Mr. Robert Fisher can offer to the court as related to your issues raised in your PCR petition, sir?
The same as Mr. Fisher. They were brother-in-law and sister-in-law. I didn't come forward also about being brother-in-law and sister-in-law. I think they should have. It makes the appearance of an unfair trial, state versus tape. You know what I'm saying? Just the appearance of them not even coming forward about that. They should have. But not only that, Mr. Robert Fisher, brother-in-law Larry Fisher was convicted of child rape and also incest, and he had 27 indictments.
So your position is that Mr. Robert Fisher could corroborate certain aspects of.
Well, I believe he might have worked for the county jail also, and we asked him, do you have any legal training? Have you worked for law enforcement? He didn't come forward about that. He also, his brother worked for Tennessee Corrections and got allegedly caught having sex with one of the inmates and got fired also there. Larry D. Fisher did. Now, on top of the other issues, I have allegedly known that, and I can ask the question, Mr. Will Fisher, that's Rebecca Fisher and Robert Fisher's brother. And that's her husband and his brother. And he allegedly did stuff to Mr. Will when he was a young boy. And they didn't come forward about it. And I can ask that question because that's part of the State versus Smith question.
Okay. Thank you, Mr. Reader.
Seggy?
So again, with this juror, your issue is that Mr. Baum didn't do effective questioning. Is that correct?
Yes, ma'am. He didn't the voir on State versus Smith, and it's other. If you look into other Supreme Court rulings, other questions that you don't ask that it can bring up any issue under biasness and an unfair trial can also be under that same category.
That's all, Judge.
Right, we're about to start number 10. Let's take a short recess. So we'll take about a 10-minute recess. My inclination is to go through all of these, not break for lunch. We'll just go through all. If there's 17 of them, we'll go through all 17 before we break.
All rise.